Hello, this is Michael Paris. This is the fourth in a series of 4 video lectures on the aftermath of Brown and school desegregation. So this video, just getting my technology arranged here. This video addresses 2 cases, Keyes, Denver, Colorado case, and Milliken, which is the Detroit busing case. Just to backtrack a little and sum up a bit, the main point I wanted to make about Green and Swan has to do with the concepts of violation and remedy. We talked a lot about what's the harm of school segregation, whether mandated by law or practiced as a matter of social fact. And you could give a number of answers to that question. The harm may be that racial classifications are irrational. The harm could be a denial of something called equal educational opportunity. It could be about equal citizenship and just the demeaning nature of intentional segregation. Could be about stigma and psychological harm to the victims, whether segregation is by law or in fact. Green and Swan give us an answer in the context of southern school districts. Now, there's 2 things there. There is an answer. We don't know what its application is going to be or will turn out to be in other contexts that are not southern. The southern context is defined centrally by legally mandated segregation by law on the face of the statute. But if you generalize from the logic of those opinions, if you read those opinions and you think, what's the harm? What's the violation? You get a clear answer. The violation, and the court constantly refers back not to Brown 1, but to Brown 2 in those opinions, Green and Swan. The answer is the wrong is the fact that a government actor is intentionally doing it, intentional segregative acts, a discrete, definable act. That's the violation. Once there's a violation defined as an intentional act by the government, the remedial power of the federal courts should be broad, should be sweeping. So Green, really, most proponents of school desegregation read Green as a great victory because the court is using strident language and specifying that the way a dual system has to be turned into something called a unitary system. So it looks like a real remedial hammer. My own take on this is that it's a very cramped and narrow understanding of violation. So sweeping remedy, but what's the understanding of violation? And Swan furthers that. Swan takes us to a large metropolitan area. It is a consolidated school district. That means we're not crossing district lines, but there's a lot of residential segregation. So you might start to think, well, what's the difference between Charlotte, North Carolina, and many other cities in the country that are not southern? Again, violation and remedy. And there's a line in Swan that says the violation defines the scope of the remedy. And we're going to correct that wrong of intentional segregation by ordering racial balance remedies across the 6 Green factors that we talked about. That is a very controversial opinion because it requires massive busing. There's a lot of 2-way busing going on that wasn't going on before to integrate the schools. And white kids are being sent from the peripheral areas of the metro area into the central cities. It is 2-way busing. So I'm going to start this presentation. It's a 4-minute wind-up on slide 26. And I have a photograph of Richard Nixon. And slide 27 gives us his comment on Swan. And this is what I mean. Here's someone who wanted to present himself as being eager to follow the law and acknowledging that it was for the court to follow the law. A lot of people thought that Swan was kind of a repudiation of Nixon's position on school desegregation. He did run as an anti-busing candidate. He made that very clear to gain Southern white support. But slide 27 gives you what his reaction to Swan, and it's a very interesting kind of comment on the legal definition, right? And I'll just read it. In speaking of desegregation or integration, we often lose sight of what these mean within the context of a free, open, pluralistic society. We cannot be free and at the same time be required to fit our lives into prescribed places on a racial grid, whether segregated or integrated, and whether by some mathematical formula or by automatic assignment. We're really doing harm when we classify people by race, even for remedial purposes, right? Neither can we be free and at the same time be denied, because of race, the right to associate with our fellow citizens on the basis of human equality. So really it's about choice and association. We shouldn't be very rigid about it, but Nixon was very clear that he would obey the court. And there was a subtext here to the voters, and to white ethnic voters in the North in particular. I'm going to follow the law. If you don't like what's happening in metropolitan areas in the South with busing, don't blame me, blame the Supreme Court. And I didn't do it, I wouldn't have done it, but I'm going to enforce the law. You can't say I'm not law-abiding and following the law. As long as he could blame the court, he was fine. Now, Green and Swan did a tremendous amount to produce actual desegregation. In the South. Hi, I'm back. Dropped my notes. So let me just give you some figures. In the school year 1967-68, about 14% of all black children in the South attended school with whites. You know, that's well over 10 years, almost 15 years after Brown, 14%. In 1968-69, that number had gone up to 23% of blacks attending school with any whites. In 1970-71, it was up to 33%. And by the mid-1980s, it would peak at around 45 to 50%. The South very quickly became the most, in terms of its schools, the most desegregated region in the country. So these numbers are also on slide 28. So the numbers I just stated are on slide 28 on the PowerPoint. So that brings us to the North. There had been cases in the North. It was up in the air with respect to whether de facto segregation would be a constitutional problem. And of course, there's a very fuzzy line between de jure and de facto. The more radical position is, look, the schools are in the public domain. The government's responsible for how students are assigned to schools. If there is segregation, in fact, the government should be responsible for it. We don't need to show an official, discrete, segregative act to have liability. And this was a viable position for a while. Keyes resolves the issue and resolves it again in favor of a very narrow legal standard. So let me tell you a little bit about Keyes. I'll give you some details on it. Denver was also, like Charlotte-Mecklenburg, a very large, sprawling metro area. It was an even bigger school district than Charlotte. In 1969, we have 119 schools. And again, I'm on slide 29. This information is there. The student population is 66% white, 14% black, 20% Hispanic. And this case was filed in 1969. So it has the same sort of genealogy as many northern cases. There's a political struggle. Liberals and conservatives are battling over school desegregation, and eventually that results in a kind of stalemate or a rejection of desegregation, and civil rights lawyers go to court. So the political battle in Denver involved a couple of neighborhoods. One neighborhood was called Park Hill, and there more working class, middle class, and whites and blacks lived in rough proximity to each other, not right next door, but not too far apart from each other. And then, like many urban areas, there was a core African-American area in the center. So in 1969, the school board itself, which was controlled by liberals, passed resolutions to desegregate the Park Hill neighborhood. It wasn't that hard to do logistically. But then there's a recall election and another school board election, and conservatives take over the board, and they rescind, before they go into effect, they rescind the desegregation orders in Park Hill. And it's at that point that civil rights lawyers file the lawsuit in 1969. They say the rescinding, the repealer bill, is itself a segregative act. But they also show with significant evidence that um, the school board had taken actions that produced segregation in the late 50s and through the first half of the 60s, especially in the Park Hill area, to keep the schools relatively segregated. What practices are we talking about? There's no law that mandates school segregation. School construction policies, where you build a school, redrawing attendance zones so as to maintain segregation as populations shift in neighborhoods, using portable classrooms if a black school became overcrowded. Instead of sending the black kids to a nearby white school that had room, they would put portables in the parking lot. And so they proved this at trial with respect to the Park Hill neighborhood. They also try to prove it for the core urban area, but there you have to go back several more decades. And it's kind of a weak case in terms of specifying acts that produce segregation. And you could stop and ask yourself at this moment, if we prove segregative practices in one neighborhood, what should the remedy be? What should we do? One answer, a narrow answer, is just desegregate that neighborhood. But what about the district as a whole? What should we do with respect to the rest of the community? And the district court, I'm moving down to, I'm now on slide 32, right? I just asked you the question that's on that slide. Say you're convinced that they did this in one neighborhood, what should happen next? The district court judge says two things. The trial judge, he says two things. First, you have proven segregation, not by law, but by government practice, which amounts to the same thing. It's intentional discrimination, intentional segregation, and therefore I will order the desegregation of that area. But second, you have not really shown me that government did things that produced the segregation in the core area. The causes are many and complex, and you can't really trace them to a government act. However, and this is 1969, so you get a sense of the legal doctrine being up in the air here. He says, however, the core central city schools are in fact segregated. You just look at who's in the schools, they're segregated schools, and they are also in fact educationally inferior. And there's a presentation about how we judge that: teacher experience, teacher training, test scores, and so on. And he says if a school is in fact segregated and educationally inferior, it violates a right that the kids have to something called, again, equal educational opportunity. So I'm going to order desegregation there as well on that theory, even though intentional actions have not been proven to be the cause of that segregation. So the district appeals, and now we go to an intermediate appellate court, the Court of Appeals, and the Court of Appeals upholds the judge about the Park Hill neighborhood because that's very comfortable. That fits squarely within the ideas we find in Green and Swan, but reverses the trial judge about the core central city area. There isn't going to be a remedy for de facto segregation. You need to prove government action producing it before you can have any remedy. And now the case is appealed to the U.S. Supreme Court, and the leading liberal light here takes over. It's William Brennan. I'm moving down to slide 35 now. The court heard the case at the end of 1972, just before Nixon's reelection, and decided it in 1973. Slide 36. I can't help mentioning this. I saw a reference in a book recently that Justice Brennan was reputed to have greeted his new law clerks, when they arrived for a new term, with a question, like, what's the most important rule of law? And they would, be nervous and not know what to say, and then he would hold up 5 fingers. Right? 5 votes is the most important rule of law. This one comes out 7-2, but it was a process of getting there. And that matters, right? Because Brennan is going to take the path of least resistance in terms of the doctrinal background we have from Green and Swan. And I think that there are 2 points to make about Brennan's opinion in Keyes that are vital. One, um, the de jure de facto distinction holds. It is only segregation by law, whether by written law or by government action, that is unconstitutional. The mere existence of segregation is not unconstitutional, and no theory of how that might be unconstitutional would be accepted. One famous scholar once said that, law kills, that, key resolutions of doctrinal questions that are up in the air actually obliterate alternatives. And this is one of those moments. So what's unconstitutional? Only intentional government action taken with the intent to produce, and which does produce cause segregation. Then we know what we're correcting. So that's Brennan's take on this, that you have to have a violation defined as intent to segregate. That's the most important part. And again, liberals tend to view Keyes as a big victory because we win and we get all-out desegregation. Actually, you kind of lose. If ideas in law matter and the conception of the wrong makes some kind of difference, no, this is not really the best result. The second thing Brennan does in the opinion, and this is, I don't know, it just has the feel of a kind of sleight of hand, works well enough at the moment, and he reasons as follows. Look, just because you've only proven segregation by law in one part of the district, by intentional action, doesn't mean the remedy has to be or should be limited to that part of the city. And he then gives us two kind of rules of thumb or presumptions. He says, if you are a civil rights lawyer or organization and you've proven intentional segregation in one part of the district, we're going to make a presumption that that has influenced segregation district-wide. Okay? And you may be able to show that there was no connection between that segregation in one part and what happened in the rest of the district, but you'll have a heavy burden of doing that. If you can't do that, we can and will uphold an order for all-out desegregation district-wide, because it's been proven that you at least intentionally engaged in segregative practices in one part, and it's a system. Every part's related to every other part. And even if you can prove that you're a school district, you will still have a kind of an evidentiary presumption against you. The second presumption is all of the other evidence about all the other areas will be cast in the light of having been shown to have engaged in malfeasance in one other place, right? So there's a presumption that, maybe your other actions aren't so innocent. He makes it very clear that based on the record, the judge can and probably should order all-out desegregation, and that's what happens. So again, the extension of this logic goes to the north, where there aren't very clear laws or even very clear practices that are unambiguously segregative sometimes. Intent is the standard, but what does intent mean? In Brennan's writing, it's not tight. It's not bad motive. It's kind of, you take an action, you know what the consequence is going to be, we're going to hold you to that. So all-out desegregation is ordered in Denver when the case is remanded, and this is clear from Brennan's opinion. Same pattern. This narrow idea of violation as almost like one we find in negligence law. A wrongdoer causing harm has to have a remedy, has to have corrective justice. And once you show the violation, the remedial force of the courts is vast indeed. It's a very heavy sort of disruptive remedy. And this again comes in the form of busing, and they had a fair amount of violence in Denver in the transition to busing. And this brings us finally to the another big defining moment. Liberal proponents of desegregation view this as the court's first wrong turn, the Detroit busing case. It's not. I think Green is the wrong turn in terms of ideas, but this is certainly a landmark in terms of what a court can and can't do, and what's going to happen after this, right? So we're in Detroit, and again, it's the same pattern. Detroit is even larger, 276,000 students in this in Detroit. And it's the same pattern of politics and political struggle between 1964 and 1965. There are liberals who want desegregation. There are black nationalists who want black control and community control of the schools. There are conservative people, lots of white ethnics who want no change because it's a very segregated community and segregated schools. And in early 1969, the liberals have control of the school board, and they pass a modest desegregation plan with respect to many of the high schools. And even this modest plan, which does something but not a lot, causes an uproar. It leads to a recall effort. And in 1969, the state this is a different wrinkle in the Detroit case, the state legislative body intervenes and rescinds the school board's resolution, and also inserts a provision for new elections. And when the new elections happen, the conservatives win, and there's no more desegregation. So the plaintiffs file suit in 1970. It's the NAACP, and they make two main arguments. We have intentional segregation. So as in Denver, they can show actions taken in the late 50s and early 60s that seem to be about maintaining separate schools. They can show actual busing to maintain segregation, how feeder patterns were changed. So there's a case to be made there. The more innovative and important part of their case is tries to make the argument that lots of government action was involved in producing a segregated metropolis, housing segregation, and that produces school segregation. So if I prove intentional segregation in housing, you should allow me to have an order desegregating the schools, because government should be responsible if it did in fact produce the residential segregation that produces the school segregation. And they put on a lot of evidence at trial about that. The defendants are saying that it's mostly de facto, that government actions didn't have much to do with it, and there isn't much of a remedy for that. After the trial judge, who actually started out being, his name was a guy named Roth, very hostile. He was a son of Eastern European immigrants. He was very hostile to civil rights lawyers. But it was one of those instances where the trial presentation, the drama, the theater of the trial, really changed his mind. Accounts of the trial show this quite clearly. He was most persuaded by this series of huge relief maps that the civil rights lawyers put up on the wall, like massive maps. And the maps basically showed that, neighborhoods didn't remain the same, their racial composition shifted. But every time the racial composition of the city shifted, whites moved away, and there was the same amount of segregation. So if you represented it in colors, you could see white people running away from black people over time, and the schools remaining segregated even though populations were shifting. He was quite taken with this evidence of white people regarding black people as inferior and unfit for association and unfit for equal citizenship. And this is reflected in what he did. He found that the state government and the local Detroit School Board had engaged in segregative acts, that there was proof of that they did things to intentionally keep the schools segregated, and racial motivation in both instances. So we got two government actors on the hook, the state itself and the local school board. The problem, however, is that Detroit is increasingly and quickly becoming an all-black city. In 1960, the student population of Detroit was 45% black. In 1970, it was 63% black. If you came in with strong desegregation remedies limited to Detroit, you would further encourage white flight. You wouldn't have any whites to desegregate with. And whites are going to private schools and they're going to the suburbs. So he did this remarkable thing. And in legal theory, it makes sense, because in legal constitutional theory, all local governments, school boards, towns, cities, all those lines and jurisdictions are really creatures of the state government for constitutional purposes. They're matters of convenience. They have no sovereign recognition or significance. The sovereignty is the state, and the state can do anything it wants with local jurisdictional boundaries. Redraw them anytime, eliminate them, whatever. That's legal theory. People don't live in the land of legal theory. They live in suburbs, and they have ideas about why they live in suburbs and what they want, or cities. So Judge Roth decides what he's going to do to fix the problem, because segregation has been proven, is that he's going to consolidate the city of Detroit with 53 surrounding suburban school districts. And the suburban district lines weren't coterminous with local government lines. They were overlapping and conflicting. School districts were their own thing. But he's going to put Detroit together with these 53 districts. We're going to go from 276,000 students to 780,000 students. About 300,000 students are going to be riding buses. They're not going to be traveling long distances, but there's going to be a lot of movement across what were separate school district lines. And so he's made this huge consolidated school district just for purposes of assigning students. All the other details, who governs the schools, what's taught, how taxing, all of that was to be worked out. And if you start to think about it, you kind of get a sense of the folly of the whole idea. And then the funny thing is, and I don't know, how this works with the timing and the political culture, but the Court of Appeals affirms him, accepts. There's a lot of evidence, a very long opinion with a lot of evidence, and the remedy seemed to be, it was actually, as a matter of logistics, logistically, it wasn't that hard. We weren't talking about great distances. We could just move kids across the perimeter and the lines and find ways to reach maybe the inner ring of the city. And it wouldn't be perfect and it would be difficult, but it seemed to have made sense to the Court of Appeals too, because they affirmed him and affirmed his remedial process, which was metropolitan consolidation. Okay, so the state appeals to the Supreme Court, and the local district appeals to the Supreme Court, and the suburbs are trying to enter and are involved in the case. And in a 5-4 decision, the U.S. Supreme Court reverses the remedial order. Right, so the decision that there was intentional segregation stands, but the court writes a long argument about why the remedy is inappropriate. And they go back to this quote in Swan, which said, "The scope of the violation determines the scope of the remedy. You've proven violations that cause segregation in Detroit. You've offered no proof that any state government action or Detroit local action caused the segregation that we find between city and suburb. And if you can't prove that, then you can't reach the suburbs. You'd have to prove a government act that caused that segregation in order to reach the suburbs." So did anyone draw a district line with intent to segregate in mind? Well, no, those lines have been there a long time, I'm sure. Did anything the state did cause segregation from one district to another? No, they rescinded a Detroit-only order or resolution. Did any of the outlying districts intentionally do things to keep minorities out? They didn't have to. The suburbs are segregated for other reasons. So to put the point differently, the idea is the remedy has to be visited upon the wrongdoers, and here the wrongdoers are Detroit School Board and the state government. You can't reach the people in the suburbs. They are sort of implicitly understood to be innocent and not implicated and not involved. So the court comes up with this argument to draw the line at school district lines unless you can prove some intentional act that caused that segregation. Why? What's good about all of these separate districts? Well, the court talks about the values of local control of education, the democratic benefits of localism, and this being an American tradition that justifies the status quo. So that liberals tend to look at this as this was the first wrong turn. This killed us. This made it impossible to desegregate increasingly segregated cities and suburbs. Maybe, I don't know what would have happened if the judge's order was upheld. I doubt the result would have been great. Later on, the court did allow the trial judge to require the state to spend more money in Detroit as a remedy for the segregation, which is kind of weird. It's not clear why money is a remedy for this, but that was upheld later in a case known as Milliken 2. One more slide I'll mention. I'm at 30 minutes, so I'm going to move on. I just went through the Milliken case there. It's summarized there on the slides in pretty extensive detail. And I just want to point out one slide which reiterates the point. No, I don't have it. Never mind. All right, I'm just going to stop there. So this is what Milliken meant, and what all of these cases meant, was that to prove segregation, you increasingly had to engage in these historical fishing expeditions that would find the wrongdoer, the smoking gun. Often actions are ambiguous. You know, if you build a brand new school in an isolated neighborhood and it opens 100% minority, is that because you want to keep minorities where they are? Or is that because the community needs and wants a new school, right? It's hard to tell often. The logic of the wrong and the idea about violation, you know, it's really problematic. It becomes hard to understand why one would want to fuss about or make trouble over or disrupt very complicated institutional arrangements, defeat expectations, to pursue racial balance remedies when there isn't much of an argument for why that matters. The argument in law is somebody did wrong and it needs to be corrected. Nothing about equal educational opportunity, nothing about belonging, nothing about diversity, nothing about equal citizenship. And you know, within 20 years, pretty much everybody had given up on it, and even its friends said it was just, you know, there was a futility problem. Even if you thought it was a good idea, politics would not allow it. The last slide on the PowerPoint is a direct link to the Eyes on the Prize segment on Boston and busing. So you can see right around when Milliken came down, the trial judge in Boston had a similar thing before him. There was vast racism, lots of intentional segregation, but he couldn't do anything other than desegregate Boston. And it's 30 minutes. You should watch it if you haven't seen it, just to see what happened when you sent poor blacks from Roxbury to relatively poor working class white ethnic neighborhoods in South Boston and Charleston. Lots of violence. So it's not a pretty picture or a pretty story, but you know, it is kind of an interesting case study of the Supreme Court really didn't acquit itself very well. Whatever your political perspective, they made a mess of it, and that mess lingers on to today. Okay, thanks very much.